good morning, very warm welcome to this in the latest of Cornerstone's housing webinar series. I'm Alexander Campbell. I'm joined by Andy Lane, and we're presenting this webinar today on social housing regulation and consumer standards. The social housing regulator is something that we've probably all heard of, but for many people in social housing practice and litigation, it's not something which comes up really on a day-to-day basis in terms of day-to-day practice and litigation. And it's for that reason that we thought it might be helpful to have a webinar giving an overview of it in light of the fact that it is a very important body for protecting tenants, and therefore it's really vital for social landlords to have an understanding of what the regulator does and the standards that it sets. We've got about 45 minutes today for this webinar, which, as you can imagine, is not long enough to go into lots and lots of deep detail about the regulator and how it functions. But we did want to take this time to give you an overview of what the regulator does, how it operates, the standards it imposes, and then Andy is going to cover some more recent legislative changes relating to the regulator in terms of the Social Housing Regulation Act 2023, and he's then going to cover lessons to be learned from regulatory judgments. So I'll be taking items 1 and 2 on that slide in front of you, and Andy will be taking 3 and 4. Before we launch into the material, we just wanted to make you aware of some upcoming events. So on the 9th of June, Kelvin Rutledge KC and Lindsay Johnson will be presenting the next in this series of webinars, and that's going to be on the topic of avoiding discrimination challenges in allocation schemes. And we also wanted to make you aware of some face-to-face events coming up later in the year. So on the 8th of September is Cornerstone's Public Law Day 2025. And on the 13th of October, we have our annual Housing Day. And more details about those events are available on Cornerstone's website, along with details about how to sign up or express an interest. If you have any questions as we go along, please feel free to put them into the chat box. And if we have time, we will get to as many as we are able to. But otherwise, we are going to provide some contact information, some contact details at the end of the webinar. So please do feel free to use those to get in touch if you have any questions or anything that we don't have time to cover today. So on that note, I will launch into the first slide, please, Andy. I'm going to start by talking about the social housing regulator and its remit and an overview of it. So really, we're most interested in relation to the regulator in the Housing and Regeneration Act 2008. Part 2 of that act deals with the regulation of social housing, which is defined in Section 68 of the Act as low-cost rental accommodation or low-cost home ownership accommodation. And when we're talking about low-cost home ownership, we're really talking about arrangements like shared ownership. Next slide, please, Andy. So Chapter 2 of Part 2 of the Act is entitled the Social Housing Regulator. Section 80A of the Act establishes the Regulator of Social Housing as a body corporate, and the rest of Chapter 2 really addresses how the social housing regulator is made up and how it functions, and really it addresses the matters which are set out in these 4 bubbles, which I'm going to take in turn. So if we go to the next slide, dealing with membership of the social housing regulator, the regulator has a chair who's appointed by the Secretary of State. It has members, and the number of members can be between 6 and 10. Those members are also appointed by the Secretary of State, but before the Secretary of State appoints a member, the Secretary has to consult with the chair of the regulator. And when the Secretary of State is appointing members to the regulator, the Secretary of State has to have regard to certain matters, and those are the desirability of appointing people who have experience and capacity in matters which are relevant to the regulator's functions, And the Secretary of State also has to be satisfied that anyone who's going to be appointed as a member doesn't have any financial or other interest which would be prejudicial to their functions as a member. And if the Secretary of State is not sure about whether someone might have a conflict of interest, the Secretary of State can require a proposed member or a proposed chair to provide any information necessary for the Secretary of State to decide that. The regulator also has a chief executive. The chief executive is actually appointed by the chair and the members of the regulator, but subject to the approval of the Secretary of State. And the legislation makes clear that the regulator, consisting of the chair, the members, and the chief exec, can then appoint staff to serve the regulator and do a lot of the day-to-day work. Thanks, Andy. So on this slide, I deal with the terms of appointment. This part of the Act, although it sort of talks about the terms of appointment, it's really mostly about how members can be asked to leave, which is why I've put the illustration there, which is my attempt to refer to being shown the door. So Section 80C of the Act deals with terms of appointment, and effectively what it provides is that members of the regulator hold office in accordance with the terms on which they are appointed. The legislation makes clear that members can resign, and then there are various grounds on which the Secretary of State can dismiss a member of the regulator. And those grounds are that a member's been absent from meetings for 6 months without permission, the member has become bankrupt or has made an arrangement with their creditors, they fail to comply with any of the terms of their appointment, they fail to declare any conflict of interest appropriately, or there's a general power to dismiss if the member is considered by the Secretary of State to be unable, unfit, or unsuitable to be a member. Next slide, please, Andy. So the next slide deals with procedure. Now, the Act really gives the regulator a lot of leeway in terms of the procedure which it sets. So what the Act says is that subject to any specific provisions in the Act, the regulator can determine its own procedures and the procedures of its committees. So, for example, one specific example given by the Act is that the regulator can decide for itself what the quorum is for any of its meetings or committees. And the Act does make clear that the regulator has to make appropriate arrangements to publish its procedure, but otherwise it's very much up to the regulator to determine its own procedures. The Act does make clear that the regulator can establish committees and subcommittees, and those committees and subcommittees can consist of people who are not members of the regulator itself. The only requirement is that any committee has to have at least one person on it who is a member of the regulator, but otherwise there can be non-members. And the legislation makes clear that with the Secretary of State's consent, the regulator can pay non-members who are serving on one of the regulator's committees. The legislation also makes clear that the regulator can delegate any of its functions to one of its committees, to a subcommittee, to an individual member, or to any member of staff. Thanks, Annie. And the next slide deals with conflicts of interest. So the legislation makes clear that when the regulator is fixing its own procedure, its procedure has to include arrangements for dealing with a conflict of interest. And in essence, those arrangements have to require that someone who has a financial or other interest has to declare it, and they have to withdraw from any function which conflicts with that financial or other interest, unless the regulator as a whole is satisfied that actually having that interest won't influence or impede the member's performance of the function in question. The regulator has to keep a register of members' interests, and generally, if a topic is being discussed at a meeting of the regulator, and a member has a conflict of interest in relation to that topic, that member's not allowed to take part in the discussions at all if what's being discussed involves a contract or an agreement with the regulator. If what's being discussed doesn't involve a contract or agreement with the regulator, the member can still take part despite having a conflict of interest, unless 1/3 of the members of the regulator decide that they should not be allowed to. On the next slide, I set out the fundamental objectives of the regulator. So Section 92K of the 2008 Act sets out two fundamental objectives which the regulator has. The first is the economic regulation objective, and the second is the consumer regulation objective. And what the Act says is that when the regulator is performing any of its functions, it has to perform those functions with a view to achieving, so far as possible, those two fundamental objectives. On the next slide, I go into a bit more detail about the economic regulation objective. And in essence, what the Act says is that this objective requires the regulator to ensure that registered providers of social housing are financially viable, are properly managed, and perform their functions efficiently and economically. The regulator has to support the provision of social housing which is sufficient to meet reasonable demands for it. The regulator has to ensure that value for money is obtained from public investment in social housing. The regulator has to ensure that an unreasonable burden is not imposed on public funds, and the regulator has to guard against the misuse of public funds. So on this slide, I set out the second fundamental objective, which is the consumer regulation objective. Now, this requires the regulator to support the provision of social housing, which is well managed, safe, energy efficient, and of appropriate quality. It requires the regulator to ensure that actual or potential tenants of social housing have an appropriate degree of choice and protection. It requires the regulator to ensure that tenants have an opportunity to be involved in the management of social housing and that they can be involved in holding social landlords to account. It requires, since the 2023 Act, it requires the regulator to ensure transparency by social landlords. And it requires the regulator to encourage registered providers to contribute to the environmental, social, and economic well-being of the areas where their housing is situated. The Act makes clear that the social housing regulator, when it's exercising any of its functions, has to do so in a way which minimizes interference. So the regulator shouldn't be micromanaging the way registered providers go about their business. And the regulator has to exercise its functions in a way that is proportionate, consistent, transparent, and accountable. And as I say, those are overarching considerations which apply to any of the regulator's functions. On this slide, I'm going to go through some of the key powers that the Act gives to the social housing regulator. So Section 93 gives the regulator a general power to do anything which is necessary or expedient in connection with the performance of any of its functions. The next bubble is that under Section 94, the regulator can carry out or commission studies which are designed to improve the economy, effectiveness, and efficiency of registered providers. And having carried out studies, the regulator can publish reports which follow from them. On the next slide, I deal with financial assistance. So in certain circumstances, the regulator can give financial assistance to a registered provider. So if doing so advances a fundamental objective, the regulator can give financial assistance for research, guidance, developing best practice, or facilitating the management of social housing by tenants. If the regulator has the consent of the Secretary of State, the regulator can lend money to a private registered provider or give them a guarantee or indemnity. And if it does give money to a private registered provider, it can make that subject to conditions. So, for example, it can loan money, but require it to be repaid with interest. On the next slide, so the next bubble, sorry, Section 97 provides that if doing so advances a fundamental objective, the regulator can publish ideas, information, research, guidance, training, advice, or education, or the regulator can arrange for an external person or body to do any of those things. And it can provide ideas, guidance, training, and so on, not just for existing providers, but also to people who may be forming a housing association. The legislation makes clear that where the regulator gives advice, conducts research, or provides any of those other services I've referred to, it can impose a charge for doing so. The next bubble deals with the fact that since the 2023 Act, the regulator has to establish an advisory panel, but Andy will cover more on the 2023 Act, so I will say no more about that. Promoting awareness. Under Section 98, the regulator has to promote awareness of its functions amongst tenants of social housing. The regulator has to consult tenants about the exercise of the regulator's functions, and it has to involve tenants in the exercise of its functions. And as I touched on earlier, that could be by way of appointing social housing tenants to committees or subcommittees. And then finally, under Section 96, when the regulator is deciding whether to exercise any of these powers, it can have regard to information or opinions that come from various people, in particular from tenants, bodies that represent tenants, from local housing authorities, or from the housing ombudsman. This slide deals with financial provisions. So sections 100A to 100E of the Act make various provision in relation to the finances of the social housing regulator. And in essence, what those provisions say is that the Secretary of State can loan or grant money to the regulator. The regulator can borrow money from the Secretary of State, or it can borrow commercially if it's doing so for the short-term management of its finances. The regulator has to keep proper accounts. It has to publish those accounts and send them to the Secretary of State. The regulator has to prepare an annual report, and the Secretary of State will put that annual report before Parliament every year. This slide deals with the regulator's relationship with various bodies. So at the time the Act was passed, we were still dealing with the HCA, the Homes and Communities Agency. So what the Act says is that the regulator has to cooperate with the HCA and had to consult the HCA on matters related to the HCA's social housing functions. The Act also says it also deals with the relationship between the regulator and the housing ombudsman, but that's a new innovation since the 2023 Act. So again, I'll say no more about that. The Act makes clear that the regulator can require people to provide documents or information to the regulator in order to assist the regulator to perform any of its functions. And the Act creates various criminal offences if someone either doesn't cooperate, doesn't provide documents or information, and doesn't have a reasonable excuse for not doing so, or if someone tries to obstruct the regulator by intentionally altering a document, destroying a document, or just knowing or recklessly providing false or misleading information to the regulator. And the penalties for doing so include a fine or prison. So on the next slide, we move on to a very brief overview of the standards which the regulator sets. So Chapter 6 of this part of the Act deals with regulatory powers, and essentially it sets out the types of standards which the regulator can fix for social housing providers. And essentially the standards which the regulator can fix now fall into these four broad categories: consumer standards, economic standards, competence and conduct, and information and transparency standards. So consumer standards, the regulator can set standards about the nature, the extent, the safety or energy efficiency or quality of accommodation, facilities or services which a social housing provider provides. And in particular, the regulator can require registered providers to comply with specific rules about various things. So for example, allocations of accommodation, tenancy terms, maintenance procedures, complaints, mutual exchange, and antisocial behaviour and domestic abuse. Andy, I'm just one slide behind you, so I'll catch up with you in a second. Economic standards. So the regulator can fix standards relating to management of a provider's financial affairs, matters of efficiency, and rent levels, which are fixed by the provider. The Secretary of State can direct the regulator to set a standard about a particular matter, or the regulator can make a direction to the regulator about what should be contained within a certain standard, so what a certain standard should address. And when the regulator fixes a standard, it has to make arrangements to bring those standards to the attention of registered providers. And the Act makes clear that having fixed a standard, the regulator can revise or withdraw a standard. And it makes clear that standards can be of general application, or they can be directed to very specific cases or specific geographical areas. The regulator has to issue a code of practice relating to standards, and the code of practice can amplify and elaborate on the standard. The regulator can have regard to that code of practice when deciding whether a provider has breached a standard, but fundamentally, it's the standard which a provider has to comply with, not the code of practice. So if we jump on to the next slide, there are 4 consumer standards. The neighbourhood and community standard requires landlords to engage with other relevant parties so that tenants can live in safe and well-maintained neighbourhoods and can feel safe in their homes. So specific examples of this are that providers have to have policies on antisocial behaviour and domestic abuse. The safety and quality standard requires landlords to provide safe and good quality homes for their tenants, along with good quality landlord services. So, to give you examples of specific matters under this standard, providers have to keep an accurate record of the condition of their properties, they have to comply with health and safety laws, they have to enable tenants to report repairing issues easily, and landlords have to set timescales for repairs and make tenants aware of those timescales. The tenancy standard is about the fair allocation of letting homes. So it requires providers to develop ways to deal with underoccupation and overcrowding. It requires providers to tackle tenancy fraud. It requires providers to have a fair, reasonable, simple, and accessible appeals process if someone disagrees with a housing allocation decision. And it requires providers generally to support tenants to maintain their tenancy and avoid unnecessary eviction. And then finally, on this slide, the transparency, influence, and accountability standard is quite a sort of detailed, complicated one, but essentially it requires landlords to be open with tenants and treat them with fairness and respect so that they can access services, raise concerns, and influence decision making. So it requires providers to collect and report annually on their performance using a core set of defined measures. The next slide deals with economic standards. So there's the governance and financial viability standard. That really sets out requirements about governance of providers with a view to ensuring their financial viability. So this deals with things like requiring providers to have a code of governance with clear arrangements for responsibilities and accountabilities of different people within the provider, like the board, the chair, the chief exec. So it's really about making sure that social housing assets are not put at risk. The rent standard sets out requirements around how providers set and increase rents for all their social housing stock in accordance with government policy. And the value for money standard requires providers to have a robust approach to decision making, requires them to regularly consider potential ways of improving value for money, and it requires providers to have appropriate targets for measuring their performance in terms of value for money. So having set these standards, how does the regulator monitor whether they're being complied with? Well, there are various ways. So the regulator, if they suspect a breach of a standard, can arrange a survey of the condition of any premises. The regulator can arrange an inspection of the registered provider's performance of their functions or an inspection of their financial or other affairs. The regulator can hold an inquiry into the provider's affairs if they suspect that the affairs are being mismanaged or the provider is not meeting a standard. And the regulator can, as part of that inquiry, can require the provider to provide their accounts and balance sheet for auditing, and the regulator can operate an accreditation scheme for managing social housing to help drive up standards. And then finally, my last slide is just around very quick in the minute I've got overview of the powers of enforcing those standards. So since the 2023 Act, there's something called a PIP plan notice, but I'll leave that for Andy. The regulator can impose an enforcement notice, which basically says that the regulator is that a particular provider is not meeting a standard or is mismanaging its affairs. The notice will specify what action the regulator requires the provider to take and by when, and the regulator can appeal that notice to the High Court. Since the 2023 Act, there's also the option of the regulator taking emergency remedial action. The regulator can impose fines, penalties, if one of various grounds apply. So again, the provider failing to meet a standard or mismanaging their affairs or failing to comply with an enforcement notice. The penalty notice has to set out why it's being imposed, what the amount of the penalty is, and what penalty has to be paid and by when. Generally, the amount of the penalty is unlimited, but if the reason why the penalty is being imposed is because the provider has committed an offence under the 2008 Act, then the amount of the penalty cannot exceed the amount which the magistrates court could impose if that matter were before the magistrates court, but otherwise the amount is unlimited. And then there's the option of the regulator awarding compensation to a victim of any failure by a provider. There's various powers of management. So in certain circumstances, the regulator can appoint a manager of a private registered provider or can appoint an advisor to a local authority. It can require the provider to transfer land to the regulator or to another private registered provider, or it can require two societies to amalgamate with one another. If there's I mentioned a moment ago the fact that the regulator can hold an inquiry into a provider's affairs. if there's an ongoing inquiry or there has been an inquiry that's now finished, the regulator can restrict the transactions and the payments that regulator can provide, so restricting dealings. The regulator can, in certain circumstances, suspend an officer, employee, or agent of a provider who's obstructing or failing to cooperate with an inquiry. The regulator can remove an officer of a private registered provider or appoint new officers of a private registered provider. And finally, on this slide, the regulator can issue a censure notice to a local authority, and a censure notice essentially identifies a particular employee or agent who's contributed to an issue of failure or mismanagement. Now, as I mentioned at the beginning, there has been some important legislative changes recently in the 2023 Act. So I will hand over to Andy, who's going to go through those and then cover some lessons from judgments.
That is wonderful, Alex. Probably the first time I've ever done one of these and people have been on time. So incredibly impressive, and obviously a very impressive presentation on what is, as Alex indicated, a very difficult subject, because for many of us, it's not something we're engaged in on a day-to-day basis. My own experience has generally been about, more recently, for example, what properties of a local authority are actually covered by the remit of the regulator. That's not something we're dealing with today, but the actual regulation of standards is not something that, generally speaking, has come up to any great degree in litigation. I should also say it's fair to remember that we're talking about 4 million plus households. Probably about 60% of those are private registered providers of social housing, such as housing associations, and the 40% local housing authorities. And there'll also be some for-profit organisations as well. And this Act itself has been in the making, particularly since the Grenfell Tower tragedy in 2017. And of course, was also given motivation by the tragedy which led to Awab's law as well. So in terms of the core objectives of the Act itself, what we have is it's there to facilitate a new proactive consumer regulation regime. And as Alex has already said, we see in particular emphasis on safety and transparency and new standards in respect of those matters. And in particular, new powers in relation to competence and the conduct of staff, and the transparency and the provision of information, as we've already heard. It's there to refine the existing economic regulatory regime, and I have to say it's not certainly weakened it in any sense, but it's not the main drive of this legislation, the economic side. It's more the consumer standards side. But it's certainly had certain amendments to the Housing and Regeneration Act. And it's also there to strengthen the regulator's powers to enforce the respective regimes, in particular the consumer regime. And Alex has indicated some of the additional powers that there have been to assist in that process. Just before moving on to the next slide, and I have less slides than Alex, so we should hopefully still finish on time. But just to remind ourselves that in terms of legislation, we are still talking about the Housing and Regeneration Act. Clearly, I'm here talking about 2023 legislation, but that largely amends the 2008 Act, which itself was subject to amendments by the Localism Act and the Housing and Planning Act of 2016, as well as certain regulatory changes from 2018. So in terms of seeing, if you wanted to see for yourself where these provisions were largely set out, it's going to be in the Housing and Regeneration Act 2008. In terms of then a summary of the reforms, what we see is an enhanced enforcement power regime. As you can also see, if anyone's been on any of our webinars before, I've learned to do the transition buttons. So this is it's really exciting for me. It's also provided enhanced ombudsman powers. And as I say, there are provisions specifically in relation to matters arising from the tragedies you see there with Awab's law and Grenfell Tower. So looking at the first one briefly, We have the question of inspections and surveys. The regulator can direct registered providers to collect, process, and publish information about their performance standards. And we see a new section 198C in respect of that. This is one of the areas where there are fines available, and as we'll see shortly, fines are now unlimited, and they can be handed out for breach of this provision, amongst others. And we see that by way of amendments to the section 20 to 27 part of the 2008 legislation. And there is also a requirement for personal personal performance improvement plans to be produced. Again, that is something that's there to try and drive up the standards and make sure that private and local authorities are thinking more about their service to the tenants and involve, as we'll see, more tenants in that decision-making process. And lastly, we have the fines and emergency action, and again, that we see that in sections 26 and 27 in particular, and that in particular aligns local authorities with the private registered providers who are already subject to many of these sanctions, and therefore it's not a totally new regime, but it is, in a sense, a refined and some may say improved enforcement process. In terms of the Ombudsman, they've published guidance for landlords. And what I would say about the Ombudsman before moving on is that it's a much more public service, in my experience. We're hearing a lot more about the Ombudsman, and we're not just done on a case-by-case basis, which of course is what we see in respect of the Ombudsman. It's more about case-by-case rather than the regulator looking and taking a step back and considering the performance of the social landlords. It's looking much more across the board and maybe taking individual cases as showing an endemic problem and requiring actions on the part of landlords. And we see there they have published guidance for those landlords, and they can order a landlord to evaluate a particular policy or practice. So if, for example, they're not happy with how they're dealing with antisocial behaviour, they can ask them to refine the antisocial behaviour policy, which of course they're required to do by law in any event. If there are issues to do with harassment, maybe again they would require that, or to do with allocation, etc. So those are matters which obviously could involve the regulator, but may also involve the Housing Ombudsman. And we see in particular various references to that in amended sections 40 and 41. And in terms of the Awaab's Law, Grenfell Tower pieces of legislation, what we're seeing there is time limits to address certain hazards. We're going to be looking shortly as to exactly when we're talking about that, but clearly they are very pragmatic and impactful changes. And we're going to see, for example, this year in October, requirements for social landlords to address damp, mould and emergency repairs within defined periods of time. We're going to see next year an extension of these requirements to include excess cold, heat, fire, collapsed properties, hygiene and other standards. And in 2027, all the remaining hazards. And for those of you who deal with a lot of Housing Act 2004 matters, you'll understand what I mean by hazards, but they're going to be requiring a time-limited rectification as well by reason of these changes, and in particular a new section 10A of the Landlord and Tenant Act 1985, which we have seen in force already with effect from the 20th of September 2023. These add on to those matters which are already in force. And as I say, that's a phased approach in terms of the full matter. Now, I've been told when we went through this briefly this morning that nobody can possibly read that. What I will assure you is that when you get a copy of these slides, and they will be sent out incidentally, you will be able to read it. All that does, it sets out a summary, which I don't propose to go through in any depth, of what the Act does. So, for example, in respect of the consumer regulatory regime, the reference at the top, and these are from the explanatory notes of the Act, it talks about the Act facilitating a new proactive consumer regulatory regime. And to achieve this, the Act makes safety and transparency explicit parts of the regulator's objectives, etc. So it merely sets out what the Act is trying to achieve. And so in terms of the changes, one of the most important changes, I've got four here, but in fact, one of the most important changes is the dropping of the serious detriment matter. And you'll see that at section 26. This was the previous requirement that had to be satisfied before the regulator would investigate a breach or potential breach of regulatory standards, and that's been dropped. They don't need to have that as being a concern. They can investigate regardless, and that's an important change, which Section 26 of the 2023 Act has brought in and amended Section 198A and 198B of the 2008 Act to that end. As I indicated and Alex indicated earlier about fines, there's a power to impose unlimited fines, both local authorities and private registered providers, and they are now unlimited fines for both sorts of landlord. They are performance improvement plans, as we've just seen, which can be drawn up by the regulator and need to be adhered to. And as has been indicated previously by Alex, there's the establishment of the advisory panel. Those advisory panels, as you might imagine, given the direction of travel, is very much going to include tenants. Rather keen on that one. Include tenants, landlords, local housing authorities. In London, for example, the GLA will probably have a membership. The Homes England maybe secured creditors, etc. But certainly tenants are very much there to give a real voice as to the performance of their landlords. And that is very much the purpose of much of these changes. And in terms of where we are now, as I say, we've had the regime in from April 2024. It seems to me that we're seeing much more in terms of regular inspections. There's clearly much more tenant feedback, monitoring and involvement. That's the whole purpose of the Act. Tenant satisfaction measures have been reported, and they were published on the 21st of March, 2025. And of course, as we've seen, particularly with the issues to do with hazards, there is a lot more to come. But I suspect there's a lot more to come on the regulatory standards more generally, particularly on the consumer standards in any event. And therefore, to finish off, just to briefly have a look at some regulatory judgments as to say, well, where are we now? As you probably already know, and this is obviously available on any good website, but particularly the regulator's website, they give a published view of whether the landlord is delivering on its consumer and economic standards. And for the private registered providers, the housing associations, that of course can cover any standards. For local authorities, the same, save that it will not cover everyone, as you can see there. But it can cover consumer standards and rent standards. The regulator expects, as you might imagine, everyone to have a good governance grade, and they're talking there about the private registered providers. A regulator, as Alex I think has already mentioned, is accountable to Parliament for the discharge of their fundamental objectives, and no doubt will be subject to select committee investigation or at least review to ensure that their objectives are being met. And in terms of the gradings, we'll have often seen these. They're often in, for those of you who read Inside Housing, you'll have often seen these. You'll have seen these in other housing publications where there is publicity given. Every landlord will have a grading for governance, viability, and consumer. So they'll have G1, G2, G3, G4, for example. One is obviously, as you might imagine, the best. They're delivering the outcomes of the standards, not a problem. 2, there are some weaknesses and improvement is needed, but it's not too bad. 3, of course, is where we're really having problems and serious failings and significant improvement is needed. And 4, very serious failings and fundamental changes are needed. And those are as I say, are given across the board: governance, viability, and consumer. And just to give us some recent examples that some of you may have seen at the end of last month, and these are consumer standards examples. These are 3 local authorities. And what I would stress is that this isn't indicative of local authorities being worse than PRPs, but it's just indicative of the kind of work that the regulator's doing and why it's doing it. But it's also indicative of how local authorities can use the process to their benefit, because you'll see the reference there to Tower Hamlets making a self-referral. And certainly one of the reasons for that is it was felt it was a much quicker way of doing so and making sure that the problems that they had already identified were dealt with in a proper manner. And you can see at the inspection, the problems there: did not have an accurate understanding of the tenants' homes because of a lack of complete surveys. A lot of the homes did not meet the decent home standards, and they had a lot of outstanding actions to do with fire safety, etc. So very practical and important inspection and results and requirements for actions. If you take another example of Reading Borough Council, they had failed to provide. Remember, these are all being given C3, so these are improvements being required. They had failed to provide an effective and timely repair service with a lot of overdue repairs. They'd only surveyed over half its homes in the past 5 years, and they had failed to provide meaningful opportunities for tenants to scrutinise their performance. And of course, one of the big things these days is about transparency and about tenants knowing what the service is doing and how it is doing. Winchester, when it got its grading, that was because it did not have up-to-date information about the majority of tenants' homes. And the last stock condition survey was as long ago as, well, more than 10 years ago. It was unable to provide assurance that it was completing required health and safety checks for all homes, and that included fire, electrical and water safety issues. And it had not been able to demonstrate that it provided all tenants with accessible information. Again, a similar problem that Reading had experienced. So what you see from that is it's a very practical, very important and very pragmatic issue. And just to recap, what you will find, therefore, in terms of the consequences of judgments generally, this is not related just to those 3 authorities or indeed any recent housing associations or authorities subject to judgments, particularly those below 2. They could be subject to fines, but that's not really what they're doing in terms of those matters. They're setting out action plans to be carried out and to be addressed so that the grading can be improved. Potentially, of course, they have the powers of intervention, and that's certainly possible if something is serious enough. And of course, from the individual landlord's point of view, there is reputational questions. In other words, there are really nobody wants to be known as not managing their stock properly. Nobody wants to be known as not knowing who's living in their stock, what the condition of their stock is. Nobody wants to be known as somebody who is not giving out proper information to their tenants. Most landlords, and certainly most landlords I deal with, have genuine motives and want to provide the best service possible. And therefore, most are trying to get to that point if they're not already there. Those are 3 of the issues. I mean, there are other questions. You can, for example, go to the extreme of having management transfer. You can have the regulator appointing managers. They can appoint advisors to local housing authorities. There can even be amalgamations. There can be suspension of officers. There can be appointment of new officers. And there can be censure notices. But as I say, what the regulator's main thrust is trying to improve the process and the operation of the landlord. And now, and this is purely my responsibility, so don't blame Alex, we have an opportunity, if anyone has any questions, for questions. Um,
So, Andy, there is one question in the Q&A, which is the question is when the Ombudsman orders something, will it be mandatory for local authorities to impose it? Do you want to take it or shall I take it?
you could take that, yeah.
Okay, so while Andy was speaking, I thought perhaps the most helpful thing I could do would be to go to the Ombudsman website and take the words directly from their mouth, as it were. So the Ombudsman's there's certainly an expectation that the Ombudsman's decisions should be complied with, but the um, website specifically says, and now I have managed to lose the page that I was going to read from, so bear with me one second. Yeah, so they have a page setting out the fact that in cases of service failure, maladministration, or severe maladministration, the Ombudsman can order a landlord to implement the remedies that have been identified. And what the Ombudsman says about their orders is that they're legally they say these orders are legally binding, meaning if a landlord does not comply, we can force them to do so via court action.
Yes, and my involvement with ombudsman has actually been mainly with the social care ombudsman, but and there is sometimes a dispute as to those reports, and so certainly there can be a genuine dispute, and indeed the local authority may itself take judicial review action if it really is unhappy with either the report itself or the suggested remedy that's being put forward. But clearly. I think, as Alex has indicated, they would expect their recommendations to be enforced. But obviously, as we know, there's been very well-known examples where, for example, where they've suggested compensation that has been refused by certain landlords at certain times. I also noticed, by the way, there was something talking about struggling to gain access to properties. Perhaps I could just briefly say on that that, of course, there are going to be situations where it looks bad on a bit of paper, but actually the landlord has been really trying very hard to carry out its proper obligations, and it may not have been assisted by the actions of some of its tenants. But of course, what a landlord can't do is just sit back and say, well, look, we went round, or we wrote the letters, or we sent the emails, or we arranged appointments and they were not kept. It's got to show that actually, because it's important, for example, to make sure that its stock is in a good condition, it's got to make sure that it checks it. And if therefore somebody isn't letting them in, it needs to make sure that it's, and one of the suggestions was injunction action. That is one of the possibilities. There may be other situations where it's decided that maybe possession action, for breach of tenancy, if it's a breach of a tenancy condition, that maybe that's an appropriate action. I mean, clearly those are last resort matters, and one would hope that one wouldn't come to that. But what a local authority or housing association can't do is simply say, well, we tried. Because obviously what they're looking for is outcomes, not just, and it's important, obviously, that you've tried, but it's important that the outcome is achieved as well.
Um,
Um,
There's also a question about where the Ombudsman can now require a provider to change its policy documents, for example, ASB. Does it publish any standard set requirements, or does it simply refer to the consumer standard? Uh, Go on, Andy, if you.
I think what would happen is that the ombudsman, through normally an individual case, will have identified that one of the failings was that the policy was deficient in some respect, and that therefore, as part of the remedy that's being provided as part of the ombudsman complaint, is that their policy be revised to include provision for, I don't know, communication. Maybe that some people can't cope with face-to-face communication; they require email or text or other forms of communication, that therefore should be part of the policy. So it's not so much prescriptive, and it's not so much confined just to the consumer standards. From the Ombudsman's point of view, they're very much looking at it from the point of view of the individual complaint and whether the tenant has been provided with the proper service. And if they haven't, and if one of the solutions or part of the solution is that in general terms, the landlord in future must adopt a better, more tenant-friendly policy or at least diverse policy, for example, then that's not only reflected in that particular case, but it's reflected in future cases. And that therefore it's a bit more kind of flexible than just saying, there's a consumer standards, put that in your policy. It's still your policy as a landlord, and therefore it's still for you to approve and you to be happy with. And you may well go further than they require.
And again, I was just checking the Ombudsman website, and they do have sort of generic information, generic guidance about things like antisocial behaviour policies, and what they think ASB policies should address, and how they should go about it. I say it's quite generic information, but
Yeah.
that is
And,
there.
and because the people who know their tenants best should be, of course, the landlords. And of course, if you have more tenant involvement in your decision making, it should be even better addressed by the landlord. And in those circumstances, of course, they're better equipped than the ombudsman and indeed the regulator to be that precise as to exactly what it should contain. Of course, there are certain things it always contains. You should always have provision about, what actions are available and when you will take those actions and what things you will consider and how you will engage with the tenant and any household member. But as I say, I think it'd be wrong to say that you simply are just following what they tell you to put in. It's still the landlord's responsibility um, for that.
So
And
then there's
it's
then a question about, does it impact on possession proceedings? I think if that question means, say, would an adverse finding by the ombudsman, on, say, a landlord's ASB approach to ASB in a particular case, would that impact on possession proceedings? Yes, I think in it absolutely could. I mean, if the ombudsman had found that a landlord's approach to dealing with ASB had been, say, seriously flawed, if a possession claim based on ASB, then that could absolutely be relevant, if nothing else, to the question of whether it's reasonable to make a possession order. So yes, I think it obviously would depend on the facts of the case, but yeah, I think an adverse ombudsman
I
finding
mean, the
should
interesting point, Alex,
be
is
done.
that that's obviously right in respect of a discretionary ground. I mean, is that if you were going on, let's say, an absolute ground, let's say somebody has breached an injunction, antisocial behaviour injunction, and that's been demonstrated, you know, will it impact upon all that? Because obviously that can only really be stopped more by way of, I suppose, either discrimination or a public law defence. And it's not, we're not talking here necessarily about discrimination. So it's a question of whether there's a public law defence, to the fact that you're seeking to apply, let's say, an absolute ground in the circumstances where the regulator or indeed the ombudsman has decided your actions are worthy of censure, or however that's expressed. Um, I haven't seen it, I must admit, and I don't think the changes are going to encourage that change because I think it's always been there as a possibility. But as Alex said, I mean, certainly if with a discretionary grant, of course, it would be a good defence because you haven't acted reasonably as a landlord, and that must impact upon the conclusion.
And then the final question we've got is about gas safety inspections, and about, in order to avoid criticism from the regulator, whether a landlord could apply to court for an injunction to enter a property to inspect the gas, even before the current gas certificate has expired. I mean, I'm trying to think about that out loud. I mean, if the tenancy agreement provides that the landlord has a right to inspect the gas on giving reasonable notice, I don't know off the top of my head that the fact that the current gas safety certificate had not yet expired would necessarily be a barrier to the landlord being entitled to try to um, uh, uh,
You would expect a landlord to be seeking to inspect well
yeah,
before the end of the
yeah.
life of the existing certificate. Um, what there has been recently, which I know is not the subject of this webinar, but there's been some very interesting information as to the ability of landlords. I remember doing an advice on it recently to actually break in to properties in order to be able to do it. Having got an injunction, well, two things. A, because some people have tenancy agreements which make such provision for that in such emergency cases, and B, even if they don't, but they get an injunction, there has been some authorities, particularly county court authorities, which have supported the notion that you can break in order to carry out the inspection as part of the injunction. And there's been some very interesting stuff I've seen on my normal kind of great legal analysis like LinkedIn. And very effective and use of the CPR by some people. So that's right. And I think, as Breeder says, they try for about 2 months before expiry normally. And as you said, forced access, and that is still quite common. As I say, a couple of years ago, I was advising on forced access without the injunction by reason of just the tenancy terms, which I think is in theory possible. But certainly, I think the direction of travel at the moment is that you can force access if you've got an injunction. And I think that's fairly straightforward now.
Okay, well, I think that covers all of the questions. So on our very final slide, we just have some contact details. So if you do, if anyone thinks of any questions later on that they want to ask, please do feel free to contact. Hopefully, the contact details will come up. But if not, please feel free to contact us via Cornerstone's website, and yeah, we'll be happy to deal with any other questions that come up. But otherwise, it just remains for us to say thank you very much for joining us for this webinar, and wishing everyone a very, very nice rest of the day.
Thank you very much.